Welcome back to Court TV Live. A big breaking news right now. Defendant Brian Walshe not going to take the stand, and there will be no defense case. That's right. He's not taking the stand, and the defense isn't calling any witnesses whatsoever. Let's go back into the courtroom now together, where this was announced moments ago.
All right. At the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walshe today. As an initial matter, does the defense still intend to call Mr. Walshe today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, sir.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion in limine to exclude evidence that the defendant pled guilty to misleading the police into Anna Walshe's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in A Juvenile applies with equal force. If the defense was permitted to tell the jury that he pled guilty to the 2 lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116 124 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion in limine to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light of my ruling.
Moved at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago I did review what the defendant filed this morning. It's just not 216, it's 318. All right, on the docket.
This is a major, major decision. I mean, let's just pause for a moment. There's now been a decision by Brian Walshe not to testify, which is his right. The jury can't hold that against him. But it changes things for the defense in so much as they cannot get into evidence the fact that his attorney postured in the opening statement that Brian came upstairs after their lovely New Year's Eve dinner and just found Anna suddenly deceased in the bed. She wasn't moving, wasn't responsive, so he panicked. All those facts I just recited here that the defense attorney put out there, they're not evidence. The jury can't consider any of that, so he can't argue any of that in close because they didn't put it in to evidence. They're choosing not to call any witnesses at all, not even a medical expert to opine more so on this issue of sudden, unexplained death. Apparently, they're relying on what they got out of the ME called by the Commonwealth.